shut out of the classroom by persons who have no authority or whatsoever under the act of the rules.
Yes.
All right.
So with this, I rest my second submission on the doctrine of discrimination based on religion. The third most important submission is that the goal of education is to promote plurality, not to promote uniformity or homogeneity, but to preserve heterogeneity. In fact, the world over, this has been very well recognized that the classroom should be a reflection of the diversity in the society. Honorable Supreme Court has also recognized in case Putswami's case more expressly. In Nalsa case, I'll place the judgments. I will not trouble the court with this thing.
Yes.
Yeah, may just give the relevant paragraphs. In 2008, 5 SCC page 33. Paras 41, 42.
Page number 2008, 5 SCC.
Page 33.
Read.
2008, 5 SCC page 33. Paragraph 41, 42, 45, 46, 54, 56, and 58, where the historic role of Akbar the Great in maintaining peace and harmony and diversity in the society has been expressly noted by the Honorable Supreme. In Navdev Singh Johar, where section 377 was struck down, 2018 10 SCC page 1. 2018 10 SCC page 1. Paras 97 by the Honorable Chief Justice. Para 4 and then para 610 by Justice Chalmeshwar. Then in Valsamma versus University of Cochin, Valsamma versus University of Cochin, 1996, 3 SCC.
Yeah.
Page 545. Paras 22 and 25.
These are for the proposition. I'll write down. We'll write down the proposition also. There should be no uniform at all.
No. This is for the proposition that heterogeneity should be maintained.
Legislation is to promote popularity.
Unity in diversity should be the motto. Plurality of the society should be third. Then when the Right to Education Act came into the force, the validity of it was under challenge. This was in the Society of Unaided Schools of Rajasthan, 2012, 6 SCC, page 1. Paragraph 239, 240, 260, 239, 261. Heterogeneity should be maintained in a classroom is the goal of the new RT Education Act. This was a statement made by the Government of India, which has been placed onto. So my very respectful submission is that if people wearing turban can be in the army, why not a person sporting a religious symbol, which is her right to practice her religion, be allowed to attend classes? Sir, it's a draconian this, where universal education is, particularly girls' education. And court may take judicial note of the fact, among the girls, Muslim girls are the least educated, least represented in classrooms. If they are shut out on the ground of such discrimination, that will be spelling a doomsday for their educational career. Very rarely they come to the college. Even such girls are being shut out on this pretext. Would be a very draconian measure. So with these submissions, I on other submissions, since it has already been elaborately argued, I do not want to cover. In reply, if it is necessary, I will get back to this. I am grateful to the court for giving this patient here.
Thank you.
Grateful, my lord. Unless there is some senior advocate designated from the Karnataka High Court, then I may be given a chance, my lord. First preference is from that.
Petition number 4. What is number?
Right.
So 308 of my lord.
Now we come to next case is 3038 of
Yes,
2022. Mr. Yusuf Hatim.
Yes, my lord.
Yes, please make your submissions.
May I please, Your Lordship? Lord, sorry. There's a lot of matter going on, you know. So there is a lot of disturbance. I speak from Bombay, my lord, and there's some problem getting too much echo in the sound, and therefore, my lord, I very often I have to repeat myself to make myself audible and to make myself properly understood by the court. My lord.
We
Am I
are hearing.
Yes.
We are hearing you clearly.
Yes.
You
Your Lordship, not a petitioner before Your Lordship, my lord, my petition are also the Muslim girls, my lord, and they have been in the pre-university classes, and pursuing second pre-university course, and wearing the headgear, hijab, my lord, without any remark or blemishes in their academic program, my lord. And they have been, my lord, stopped from attending these classes from the 3rd of February 2022, my lord. And after this impugn order has come, they have been totally denied their right under Article 25, Redress 19(1)(a), 21, and the right to education. And my lord, similar issues have been raised in other petitions. And my lord, I will not repeat many of the things which have already been adverted to by the learned, my learned friends who preceded me. And my lord, I totally endorse, my lord, all their arguments advanced by Mr. Sanjay Hegde, Mr. Kamath, and also Professor Ravi Kumar, my lord, who just addressed and completed arguments at some time. But I seek your lordship's indulgence, my lord, to merely elaborate one or two points very briefly, which I believe that they have touched upon it, but they have not made any elaborate arguments on that. My lord. The first point that I would like to say is this, my lord, that this particular impugn order suffers from manifest arbitrariness. It's manifestly arbitrary, and it also offends Article 14. Your lordships are well aware of the legal propositions authentically laid down by the Supreme Court, my lord, in the case of Saira Banu. Pardon. Laid down. My lord, I briefly draw your lordship's attention to only three paragraphs from Saira Banu's case, my lord. And when I make my submission as to how this whole exercise of preventing the Muslim girls to wear hijab is manifestly arbitrary, my lord. Your lordship will see, my lord, it is, my lord, your lordship has got, I believe, the case in the compilation. It is 2017 9 SCC, page 1. 2017, volume 9, SSC, page 1, my lord. And my lord, I am reading very briefly only certain sentences from paragraph 100 at page 97, my lord. From the of my lord, the Justice Nariman.
On what proposition you want to cite this, Saira Banu?
Yes, no, it starts from 100 proposition.
On manifest arbitrariness.
Pardon, my lord?
Pardon? You are citing.
Manifest arbitrary.
All right.
Manifest arbitrary. Now, order along, may I first read from paragraph 95, where the concept of arbitrariness and manifest arbitrariness is totally defined. Page paragraph 95 at page 95. On a reading of this judgment in natural resources allocation case, it is clear that this court did not put McDowell's as being an authority for the proposition that legislation can never be struck down as being arbitrary. Indeed, the court, after referring to all the earlier judgments, and Ajay Hamza in particular, which stated that the legislation can be struck down on the ground, in particular stated it can be struck down that it is arbitrary under Article 14, went on to conclude that arbitrariness, when applied to legislation, cannot be used loosely. Instead, it broadly based test stating that if a constitutional infirmity is found, Article 14 will be interdict such infirmity. Such a constitution is found in Article 14 itself, wherever legislation is manifestly arbitrary. That is, when it is not reasonable, discriminatory, not transparent, capricious, biased with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to the norms which are rational, informed with reason, and guided by public interest. Then, my Lord, your Lordship will turn to paragraph 100. The part which I have already read. That we have already seen that one of the tests of challenging the constitutionality of subordinate legislation is that subordinate legislation should not be manifestly arbitrary. Also, it is said that subordinate legislation can be challenged on any of the grounds available for challenge against plenary legislation. Now, my Lord, this is what is before your Lordship impugned order or the resolution is a piece of a subordinate legislation. The test of manifest arbitration is well explained in two judgments of the court and Kodai Distilleries and State of Karnataka. And then, my Lord, they have quoted paragraph 13 from the Kodai Distilleries case. And trouble your Lordship with that particular paragraph. It is next.
You may not, sir, you may not trouble us there because manifest arbitrariness has become a ground for striking down plenary legislations. So Kodai is overruled. Overruled decision need not be read. Now we have to show the decision is arbitrary. Earlier that was confined to delegated legislation, subordinate legislation, whatever name they may have, but never extended to the plenary legislations. Now they are included in plenary legislation. Now, based on that premise, you can build the argument now. Overruled decisions.
Coming to how this act is arbitrary in the facts of the case, my Lord.
Yes.
Now I will turn to the affidavit or the response that is filed by the government, my Lord. And let us see, my Lord, that how and in what circumstances this particular impugned action or the state action was taken, my Lord. So your Lordship had turned to the rules which are quoted, which my learned friend Dr. Kumar has already pardon me?
Yes.
Your Lordship will see that under these rules, that Rule 11 provided that there should be a notice if you want to if you want to prescribe a uniform of 1 year prior notice.
That is for changing the uniform, not prescribing. Please read 11.
Every recognized may specify its own set of uniform. Such ones specified shall not be changed within a period
for changing, therefore it that applies where you want to change the uniform. For prescribing, no notice.
1 year advance notice will be given.
I'm applied to your Lord. When an education institution intends to change the uniform as specified in Sub-Rule 1, above it shall issue notice to parents in this regard at least 1 year in advance. Here in this particular case, what happens? that these girls are also wearing the headcraft since they've joined the institution.
Whether it was part of the uniform.
Not uniform prescribed, it does not also prescribe that nothing else should be done. Supposing a girl is wearing a glass, can you take, she will wear the glass of a particular color only? And you bring the different color of the glass that you are not permitted? You cannot take it so strictly and rigidly that when you say that this is the uniform, and uniform must also include something else that is also worn by her. Supposing she is not wearing, she is wearing a shoe and they are wearing chappals. It's not prescribed. And tomorrow's day you will not wear chappals, you will wear, and therefore you are prohibited from entering the school. So, my lord,
whether any headdress was prescribed in the uniform?
No, it was not prescribed. So, but the footwears were not prescribed.
It was neither part of the uniform nor prescribed as uniform.
That was a mandate that you have to wear the uniform, and it's not a case of the girls that they were not wearing uniform, but they are merely putting one more apparel on their head. Supposing, my lord, a girl comes barefooted one day, can she not come? She is wearing the uniform, but next day she says you will wear chappals, or you will not wear chappals or footwear in the classroom. And some girls start wearing chappal. And on that girl said, you go get out and you don't come into my class and stand out. So, my lord, these are the so therefore, my lord, what happens when we say uniform, we can't so strictly confine to the dress which is worn. But what is the practice which was there? What was the practice adopted in the school, and all of a sudden you change it? Is it not, my lord, reasonable or fair that you should give at least a notice to the other side? And now you will not be allowed to wear, or why should you not change? And the reason why we are not changing, the fairness would require that they should be informed, and the fairness also requires that they should be heard as to why they are insisting on changing. And thereafter, my lord, the parents teachers committee is also formed, with a view not to create any kind of a trouble in the school. And that is also, that procedure is also not followed. That is the case of university. And
you say that notice was required to be given first.
Notice
before.
Fairness requires that notice to be given. Rules may or may not require. But fairness requires, and that is one of the grounds on which I can raise the plea under Article 14. Is it a fair procedure? On the ground of fairness, it is required that they should have been heard. The parents should have been heard. The girls should have been heard. And if they did not want to give the notice, that they should have asked the parent teachers committee which was formed. And try to, your lordship will see, that Rule 12, Sub-Rule 5, which is the internal page 11 of the government's response, my lord. The functions of the parent-teacher committee shall be as follows: to redress the grievances of the students and their parents. Why the parents and teachers committee was not consulted? With respect, this is a question that I'm putting to myself. Was it not fairness? What is that tearing hurry with it? The practice which is there in the school for nearly since the day when the girls are admitted or have taken admission into school, they want to change it. What is the need for this tearing hurry? The tearing hurry is this, that some boys are or some students are objecting, and are they objecting on the ground of the religion? But this is it's an opposition to the girls' zone. That opposition as to why they want to wear a different dress, on what ground, on what they are claiming that. They are not placing their claim on any religion or any of the rights. And to accommodate, because you are objecting, you don't come. Is this fairness? The all the more reason why they should have called the parent teacher committee and to redress the grievances of students and their parents, if any. Call both the sides together, talk it over to them, and bring a solution. At home, the government did not even. So these are the grounds of manifest arbitrariness.
Arbitrary.
Totally
All right. All right.
and this is being done only on the ground of duty. And that point has been very elaborately explained by my learned friend,
Yes.
who spoke to your court before me, and so I will not repeat those grounds.
All right. All right. Now, anything else?
Not your lordship will see. Then your lordship will see that the fact that it is being done because of the opposition of some other students is also recorded in the impugned order, in the government response itself, and also in the impugned order. So it is partisan. So it is totally unfair, and therefore it falls within the mischief of the manifest arbitrariness, which is a part of Article 14, my lord, and therefore it has to be set aside. Now, your lordship will say that my learned friends Sanjay Hegde and Mr. Kamath will elaborately explain the Article 25.
Yes. That we have done.
No, your lordship will see.
Now we come to.
No, your lordship will see. I want to
Yes.
one point that they have not stated, which I would like to slightly elaborately state before your lordship, and your lordship may give me some patience hearing on that. That under Article 25(1), when the right is based on Article 25(1) and also 19(1)(a), what is necessary is that the entertainment of a conscientious belief by a particular individual. Your lordship knows very well that Article 25 deals with the individual's freedom of conscience. Now, your lordship may kindly please turn to Article 25(1). And the distinction that I want to draw is this.
What do you want to?
I'll tell you.
Yes.
I want to tell your lordship that when the right is claimed under Article 25(1) as a matter of conscience, then it is not necessary to go into the question that whether that belief is held by that person is an integral part of his religion or not. The question whether a particular practice, religious practice, is within the integral part of the religion is relevant only under Article 26(b). Then it talks of the denominational rights, and not when the person or the petitioner before your lordships are making the case under Article 25(1) about a religious belief. Now, your lordship will see Article 25(1). Your lordship are very familiar with the words, but I'm just emphasizing one thing. Subject to the public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience. But then drawing distinction between the two, freedom of conscience and a right freely to practice and propagate religion. The conscience would mean is a very wider term. There are people who may not believe in God, yet they are entitled to that belief in conscience. There are people who believe in universality of religion. They may not accept any one particular religion, but they believe in all religions. They're entitled to that belief. And if they come before your lordship and say, okay, this is my belief, I should be protected. And then the question, what is the integral part of your religion? In my respectful submission, that is not necessary. And this very issue is now being referred to the 9 judges bench, and in reference from the Sabrimala's case, and therefore, this question, how far the court can interfere with the religious belief of the people and entertain all the arguments relating to that whether they are in consonance with this article or that article.
Yes.
But therefore, my lord, in our case, my lord, no doubt, my learned friend Mr. Kamath has dealt with that question and said it is an integral part. Wearing a hijab is an integral part, and there he has, my lord, laid the basis for that by referring to his own pleadings and the reference to the certain Quranic verses over there.
We have understood. You are saying that it is not necessary that it should be an essential religious practice for the purpose of attracting Article 25(1).
And the belief has to be protected. And
Yes.
then you are that this particular act is also forms part. The belief also comes part of the freedom of expression in 1918. And your lordships are very, very much familiar with the Puttu Swami's case, my lord. And my learned friend Mr. Hegde as well Mr. Justice Kamath referred to the view of Justice Chalameshwar, in which he said that a right to believe also the part of the freedom of expression contained in under Article 1A, 19(1)A. That passage is read before your lordship. Now, having read that passage, my lord, I will also like to draw only one more paragraph from Puttu Swami's judgment. Now, the subject begins, concept and Manekan interplay between the rights. Your lordship has got that judgment, my lord, that 2017-10 SCC page 1. And therefore, my lord, starts with paragraph 21, and I will not, my lord, read those paragraphs. And there they trace the history of the development of the entire theory of the interplay of those articles. And your lordship may directly come to the paragraph 24, by page 350. I will not read the whole paragraph, but only the relevant extracts from that paragraph, my lord. If your lordship may kindly see 1, 2, 3, 4, 5, 6. And the 7th line from the top of the paragraph, my lord. The jurisprudence foundation, your lordship got it?
Paragraph number?
24, my lord. 359. The jurisprudential foundation which held the field 66 years ago in MP Sharma and 50 years ago in Kharak Singh has given way to what is now a settled position in constitutional law. Firstly, the fundamental rights emanate from the basic notions of liberty and dignity and the enumeration of some facets of liberty as distinctly projected rights under Article 19 does not denude Article 21. So all the articles have to be read in conjunction with others, and one fundamental right reinforces the other. One doesn't denude the other. And it is expansive ambit. It is expansive ambit. Secondly, the validity of a law which infringes a fundamental right has to be tested not with reference to object of state action, but on the basis of its effects on the guarantee of freedom. And the lordship will say that here the impact is important, not the object with which they are doing. What is important is that they want uniformity, they want discipline, but doing this, are you impacting the rights of the others and the rights of the petitioner or not? And here the impact is on my right of 25(1), freedom of expression, my right of expression 91A, my right to take education under Article 21. All this has to be sacrificed in the name of the so-called name of maintaining discipline in the court. Are there no other ways in which disciplines in the court can be maintained? Why are the Muslim girls who conscientiously believe that we must wear the hijab should be put to a Hobson's choice now? It's a Hobson's choice that either you educate yourself or you look after your conscience. Why? Is this fairness? Is this a state action? Guarantees the freedom which are guaranteed in the Constitution, and this kind of Hobson's choice which is placed on the girls, my lord, should be disregarded. And there your lordship will see that this action which is they have launched upon is also opposed to fundamental duties of a citizen, guaranteed under Article 51A, and my lord is also shown and incorporated a statutory form in Section 7.2 of the Karnataka Education Act. Your lordship says Section 2, Karnataka Education Act. Your lordship are very familiar, but they are actually reproduced in the Act itself. The lordship may turn to subsection 7 of the Karnataka Act, and we say that under subsection 1 may also include schemes in respect of and come to cross G. Clause D. 7 subsection 2 clause D. Inculcation of the sense of the following duties of citizens enshrined in the Constitution, namely, and then my lord, they are enlisting all the duties. And my lord, your lordship may see the Roman 5 to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, and sectional diversities to renounce practices derogatory to the dignity of human. So, my lord, this particular practice, are we supposing to promote harmony or dissension on the basis that your wearing particular hijab is disturbing us? Is it not a violation of the constitutional duty, the fundamental duty which is expressed in Article 51A? And incorporated, why is it incorporated by the legislature, my lord, in subsection 2? And your lordship has section 133. In what circumstances section 133 can be invoked, my lord? It is for the purposes of the Act. The Act is to promote harmony. The purpose of the Act is not to create a dissension among the students. And when the established practice is there, then why should we have this kind of an attitude? Why should the school or why should the government come out with this type of an activity or this type of impugned sub-legislation? Then harmony, the spirit of common brotherhood, are we promoting that? Among all the people of India, transcending religious, linguistic, regional, social diversity, renounce politics, derogatory dignity. That is
Yes.
Then we not very next, value and preserve the rich heritage of a composite culture. The Constitution itself may not takes into account the diversity that exists in our country.
All right, Mr. Yusuf, we have understood what you are saying. Will you be able to finish today? Because now we are at the end of the day.
If your lordship may give me some time tomorrow, I'll be happy.
Any other point to elaborate?
Yes, my lord. The other point is very important point, my lord, that this is also, my lord, mainly referred to by Mr. Thomas in his, but he has not elaborated that particular proposition, the doctrine of proportionality. The doctrine of proportionality, my lord, totally ignored. I will like to dilate a little, my lord. I will not take much time. I will not repeat whatever my learned friends have said. I am merely trying to elaborate some points that they have merely referred to. And I am making a very important point.
That you elaborate in your written submission. Give the written submission. We will consider.
Your lordship, give me 10 minutes more. I will just refer to it, my lord. I'll just refer to it. Your lordship,
yes, we have noted.
Doctrine of
we have noted proportionality. You want to elaborate on that we have already noted it. So if you want to elaborate it, give it in written submission. We will
Then your
see
lordship,
that.
either you give me 10 minutes today or you give me 10 minutes tomorrow. I will not go in detail on it. Because what is the doctrine of proportionality, my lord? What are
What more you want?
components? That I just want to read, my lord, and I want to show to your lordship a judgment of the Supreme Court, my lord, in which they have shown that what is meant by doctrine of proportionality and how that has been totally ignored here, my lord. If your lordship gives me 10 minutes more today or 10 minutes tomorrow, I'll finish it. And I promise your lordship, I will not, and as your lordship has been kind enough to give us the permission to put a written
Finish your arguments today,
Lordship.
so that we may hear the others.
Your lordship. Much obliged. My lord, I will request your lordship to judgment. My lord, it is in the case of Modern Dental College and Research Center and others versus State of Madhya Pradesh, reported in 2016, 7 Supreme Court cases, page 353.
Yes.
I'm sorry, my lord. I request my instructing advocate, my lord, to hand over the copies of those judgments to your lordships, my lord.
Yes. Paragraph.
Yeah, Lord. Paragraph 59, my lord. It is at page. Paragraph 59. Page 673. My lord, at page 412.
Yes.
Your lordship is a page, paragraph 59, my lord. I will skip it because they merely reproduce 96. Lordships are very familiar with it. Then, my lord, I read sections, paragraph 60, my lord, which is of utmost importance. Another significant feature which can be noticed from the reading of the aforesaid clause is that the state is empowered to make any law relating to the professional and technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. Thus, while examining as to whether the impugned provisions of the statute and rules amount to reasonable restrictions and are brought about in the interest of general public, the exercise that is required to be undertaken is the balancing of fundamental rights to carry on occupation on one hand and the restrictions imposed on the other hand. This is what is known as the doctrine of proportionality. Jurisprudentially, proportionality can be defined as a set of rules determining the necessary and sufficient conditions for limitations of a constitutionally protected right by a law to constitutionally permissible. According to Aaron Barak, former Chief Justice of Supreme Court of Israel, there are 4 subcomponents of proportionality which needs to be satisfied. A limitation of a constitutional right will be constitutionally permissible. It is designated for a proper purpose. Now, my lord, your first thing, your lordship, was our submission that this particular impugned action is not advancing the purpose at all. Purpose of the act. The measure undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. The advancement, the harmony is the real purpose of the act. And the measure taken by them will go much against the provision of harmony and also the fundamental duties that are enumerated in the Article 51A. Then 3, measures undertaken are necessary in that there are no alternative measures that can similarly achieve the same purpose with a lesser degree of limitation. Now, why not, my lord, this? It's assuming that they want to have a uniformity, want to have discipline, then why not consult? Why not consult the people who are the stakeholder and who are the person affected, whose rights are impacted? sorry, my lord, that there needs to be a proper relationship, proportionality, stricto sensu, of balancing between the importance of achieving the proper purpose and a social importance of preventing the limitation of the constitutional right. What is the constitutional right, my lord, here, which are infected and infringed? Article 25(1), right to my conscience, right to my expression, my lord, right to have my education, my lord. That's totally disproportionate. Totally disproportionate.
All right.
This is the ground on which, my lord, we attack. These are in addition to all the grounds which are mentioned by my learned friends, the three of my learned friends who preceded me in addressing your lordship. And my lord, I humbly, my lord, thank your lordships, my lord, for inexhaustible patience in hearing this matter.
All right. Thank you.
Your lordship will give me the liberty, my lord, to file my written submissions, my lord. My lord, your lordship may prescribe some time within which we have to give. And my lord, I want to make clear, my lord, one thing, that these are all grounds which are advancing at a stage of interim stage. I think the hearing of the interim application is going on, and not the final hearing. There is some confusion in my mind, my lord. Your lordship may forgive me for putting it before your lordship.
Yes. What?
Interim applications are not yet disposed of. So this is the hearing on interim applications. Otherwise, we would like to argue.
We do not know how you people have started arguing. We have started hearing. That is all.
What are we arguing? The lordship have already passed.
I don't know whether you are making final submission or making your submission on interim relief application, because that has not been clarified.
Final, my lord. 10 hours your lordships have been hearing. It has to come to an end. It cannot go on.
And what are the interim orders now? How is the
It has to be
interim
final, my
application
lord.
disposed of?
Our lordships have been
My lord,
so
we will
gracious in
like
giving
to
such
know
a
how
time.
the interim
Has to be
orders are
final.
disposed of, interim applications disposed of. Your lordship has granted certain
We have not disposed of any interim relief application. Let it be very clear.
My lord, sir, hearing
So
is
I
final.
think, my lord, that these are the
On the first day, we had passed some interlocutory.
establish only prima facie.
That is all.
At interim stage, my lord, you have to establish only prima facie case.
All right. We have heard Professor Ravi Verma Kumar in writ petition number 2347 of 2022. Mr. Yusuf Hatem Mukhalle, learned senior advocate,
Muchala.
has argued on writ petition 3038 of 2022 for the petitioners. Put up tomorrow. Now, put up tomorrow at 2:30. We'll continue. We are left with writ petition number 3148
Please.
of 2022. That is a PIL.
To start with, Milord.
3424 of 22. That is also a PIL.
Please.
This 3424-22, there are some office objections which have not been removed. So only 2 writ petitions have been left
Please.
to be heard on behalf of the petitioners.
Tomorrow I may permit it to start with, Milord. So I'll conclude within 10 minutes, Milord.
My lord, my petition 341, it is also complete. I have been waiting for
3148 is my petition.
3418. That's also complete. Is also required to be heard whenever your lordships will get time.
My lords, I'm party in person, Dr. Vinod
Let me
Kulkarni.
make one
PIL
submission.
is 3312.
One submission.
In 3 minutes, I'll finish off my submission, my lords.
In WP 2146, IA number 5 has been filed. Court may kindly recollect yesterday for some technical reasons it was not considered. A proper application has now been made, IA number 5, seeking a clarification, saying that its students will abide by the whatever uniform insisting upon, just to use the same dupatta to cover the head. Only no additional dress, or seeking a clarification. Let the students get back to the class.
I am a
Sorry.
petitioner in person. My lord,
Just a minute.
Number 5.
Just a minute.
IA number 5 में kindly be करो. Kindly look at the
IA
page.
number 5 of 2022 in WP number 2146. Planet Advocate General appearing for respondents informed that they received the copy of this application. He intends to file the objections to this application. He prays for is allowed. 2 days time to file the objections.
my
My
lord,
lord, before writing, I make one humble
I'm
submission, my lord.
petitioner in person.
I connected to your lordship from Delhi, my lord. I have one submission. My petition was, your lordship was please yesterday to club my petition 3418. That was an order passed by your lordship. Whenever your lordship will get time after hearing other matters, my matter may be also. There's a separate.
Which is your petition?
3418 of 2022. Huzaifa is title. Yes. 3418.
3148 hai.
Yes.
It is 3148.
Yes, my lord. Huzaifa. Title is Huzaifa. Yes.
Yes,
Huzaifa.
we will hear you.
Please, your
My
lord.
lord, I am petitioning in person. I filed intervention petition in writ petition 2347 of 2022 today itself. So either I may be granted time or this is very small petition. In that we have given the reasons that it should be not allowed their petition. So those grounds we have pointed out in our intervention petition. So that we may be granted time or it can be read by the lordship. Today it was filed, my lord.
Written submission. What do you have filed?
Intervention petition, my lord.
Intervention applications will not hear. Sorry.
But
We'll
that-
hear the petitioner counsel only.
My lord can read, the time may be not granted with the very material points for the assistance of.
If required only, then we will permit, otherwise not.
Yes.
Take it that we are not permitting anyone to intervene.
No, but that could be read, my lord, for the administration of justice. That lordship, that's a very small petition.
Now there's one IA filed by Mr. K. Kotwal, advocate. R. Kotwal.
Please, lords.
Yes,
Please,
you have
please,
moved an
lords.
application for impleading
Please,
as proposed.
I'm not pressing that application. I am not pressing that IA number 1, my lords. Since I have already
Because what we find, we have also filed an impleading. Why not cost should be
I am
imposed?
not pressing the IA number
Same
1.
ratio.
How
IA number 1 is
without
not pressed, my lord.
86 है ना?
that IA 1 of 2022 in writ petition 2347 is dismissed as not pressed.
Please, oblige, my lord.
My lord, I stand corrected, but it is 3586.
Does not want to press this application. Dismissed as not pressed.
My lord, 3586 is my question. Sorry, my lord. I stand corrected. 3586. 3586.
Yes.
Yes,
We'll hear you.
please.
We'll hear you when your turn
Please,
comes.
grateful, my lord. I am highly obliged.
Lordship, may I make one submission, Lordship? In first two petition, state has filed objections, Lordship. Permission may be granted to me to file rejoinders, Lordship. Because some facts they have stated, I will file written rejoinder.
Whatever you file it. Nobody will stop.
My lord, I am Dr. Kulkarni, party in person in WP 3312. If you can kindly hear me for 2 or 3 minutes, I'll be obliged, my lords. I am Dr. Kulkarni, party in person in WP 3312. If you can kindly hear me for 2 or 3 minutes, I'll be obliged, my lords.
Matters, petition 2347 of 2022 on Karnataka matters.
May it please, my lord. Just before my learned friend, Mr. Kamath begins, yesterday your lordships were taking a list of the matters, IAs in support of the petitioner. I'm sorry I missed it out. I also have an IA number 13, and it's by a women's rights organization. Your lordships will make a note of it. Whenever your lordships permit, I'll argue in my turn.
You moved an application for intervener.
That's right, I'm an intervener supporting the petitioners, on multiple grounds.
Which writ petition you have moved?
Item number 1, in WP 2347.
All right.
Yes, grateful.
May it please, my
lord. Lordship.
Yes.
I filed an affidavit before in the morning, Lordship. It also is the record, Lordship. I just wanted to point out bring the fact before this honorable court. The order which is passed by this honorable court, it is grossly misused by the state lordship. But if kindly take the para number 11, the order, it clearly says that it is only respect of those colleges where college development committee has prescribed the inform. In spite of that, they are imposing it to every institution's lordship. Muslim girls are forced to remove their hijabs. Even yesterday in Gulbarga, government officials went to Urdu schools. They forced students as well as the teachers.
Have you moved any application?
I have given affidavit, lordship, in that aspect to.
Affidavit will not serve the purpose. You move an application for clarification.